Hello, everyone. Welcome to this lecture on special contracts under the Indian Contract Act 1872. In this video, we are going to understand one of the most important areas of contract law, especially from the exam point of view. Special contracts are not just theoretical concepts, they are part of our daily commercial and legal life. And that is why they are repeatedly asked in the university as well as competitive examinations. Special contracts are different from ordinary contracts because they involve special relationships and special responsibilities. These contracts based on trust, security, or representation, and because of this, the law gives them separate treatment under the Indian Contract Act. Topics like indemnity, guarantee, bailment, pledge, agency, surety, lien, and finer rights all fall under special contracts. All these special contracts are mainly covered under section 124 to 238 of Indian Contract Act. In this lecture, I'll explain each concept in a very simple and practical manner so that not only understand the law but are also able to write clear answers in the examinations. So let us begin our discussion on special contracts step by step, starting with the first and most basic concept. Now let us start with indemnity. In simple terms, indemnity means protection against the loss. One person promises another person that if any loss happens, the loss will be taken care of. The loss may be caused by the promiser himself or it may be caused by some other person. The basic idea is that one party should not suffer financially because of a particular risk. In a contract of indemnity, there are only two parties involved. The person who promises to compensate is known as the indemnifier, and the person who is protected is called the indemnified. Under the Indian Contract Act, indemnity is defined under section 124. A very important point to remember is that the indemnifier does not become liable immediately. His liability arises only when the indemnified actually suffers a loss. If no loss takes place, then there is no obligation to compensate. The main purpose of a contract of indemnity is the shifting of a risk. Instead of one person bearing the entire risk alone, the risk is transferred to another person through an agreement. This is the reason why indemnity contracts are very common in business and commercial transactions. The most common example of indemnity is insurance. When a person takes an insurance policy, he pays a premium to the insurance company. In return, the insurance company promises to compensate him in specified loss occurs. In such a loss due to accident or fire. In this case, the insurance company is the indemnifier and the insured person is the indemnified. The another example can be seen in business dealings. Suppose one person promises another that if any loss occurs while dealing with the third person, that loss will be compensated. If the loss actually happens, the person who gave the promise must compensate. But if no loss occurs, then there is no liability at all. The next one is guarantee. A contract of guarantee is a contract where one person promises to perform the obligation or discharge the liability of another person if that person fails to do so. In simple words, it is a promise to take responsibility in case someone else defaults. The main purpose of a guarantee is to give security and confidence to the creditor. In a contract of guarantee, there are three parties involved. The person who gives the loan or credit is called the creditor. The person who takes the loan and is primarily responsible is called as the principal debtor. The person who gives the guarantee is called the surety. Under the Indian Contract Act, A contract of guarantee is defined under section 126. An important legal point to understand is that the liability of the surety is secondary. This means that surety becomes his liable only when the principal debtor fails to perform his obligation. However, once default occurs, the liability of the surety becomes equal to the important of the principal debtor, unless otherwise agreed. An example of guarantee is a bank loan. When a person takes a loan from the bank often asks for a guarantor. If the borrower fails to repay the loan, the bank can recover the amount from the guarantor. In this situation, the borrower is the principal debtor, the bank is the creditor, and the guarantor is the surety. Another example can be seen when a parent guarantees the education loan taken by his child. If the child defaults, the parent, as a security, becomes legally responsible to pay the loan amount. The next one is bailment. It is another important in Special Contract Act. Bailment means the delivery of goods by one person to another for some specific purpose. Upon a contract that the goods shall be returned or disposed of the once that purpose is completed. The important thing to understand here is that only possession of the goods is transferred, not the ownership. Ownership always remains with the person who delivers the goods. In a contract of bailment, there are two parties involved. The person who delivers the goods is called the bailer, and the person who received the goods is called the bailee. Under the Indian Contract Act, bailment is defined under section 148. Bailment applies only to movable goods. Money or immovable property cannot be subject of bailment. The purpose of bailment is to allow goods to be used, kept safely, or dealt with in a particular manner without transferring ownership. Because of this, the law places certain duties on the bailee to take reasonable care of the goods and return them after the purpose is fulfilled. An example of bailment is when we give our clothes for dry cleaning. The shopkeeper receives our clothes only for cleaning and must return the same clothes after the work is done. The another example is when a person gives his car to a service center for repair. After the repair work is completed, the car must be returned to the actual owner. Now let us move the next concept, that is finder of goods. A finder of good is a person who finds goods belonging to someone else and takes them into his custody. Even though the finder is not the owner of the goods, the law recognizes certain responsibilities and rights in favor of the finder. The basic idea is that a person with honestly finds and takes care of goods should receive legal protection. Under the Indian Contract Act, the finder of goods is treated as having the responsibility of a bailee. This means the finder must take reasonable care of the goods, just like a bailee would take care of goods entrusted him. The finder cannot use goods for his own benefit and must act honestly. Section 168 of the Indian Contract Act deals with the responsibility of the finder of the goods. Even though there is no contract between the finder and the owner, the law creates a relationship similar to bailment in order to protect the goods. For example, if a person finds a lost wallet on the road and keeps it safely, he becomes the finder of the goods. He must take reasonable care of the wallet and should not misuse it. Another example is finding a mobile phone in a public place and keeping it safely until the owner is being traced. Now let us move to the next special contract, that is pledge. A, a pledge is a special kind of bailment. In a pledge, goods are delivered by one person to another as a security for the payment of debt or performance of a promise. So, whenever goods are given as a security, the contract is known as pledge. In a pledge, the person who gives the goods as security is called pawnee, and the person who receives the goods is called pani. Under the Indian Contract Act, a pledge is defined under section 172. Since pledge is a type of bailment, all essential elements of bailment are also present in a pledge. The main purpose of a pledge is to secure the interest of the creditor. The pani has certain special rights, such as the right to retain the goods for payment of the debt, interest, and necessary expenses incurred for the preservation of the goods. A very common example of pledge is a gold loan. When a person gives a gold to the bank or a finance company as security for the loan, the gold is pledged. Another example is when shares or other valuable goods are given as security for repayment of the loan. Now let us move to another very important special contract act, that is agency. Agency is a legal relationship where one person is authorized to act on behalf of the other person. The person who gives authority is called the principal, and the person who acts on behalf of the principal is called the agent. Whatever lawful acts that agent does within the scope of his authority are binding on the principal. Under Indian Contract Act, agency is defined section 182. One important thing to understand is that agency can exist even without consideration. The focus in agency is not on consideration but on authority and representation. The purpose of agency is to allow one person to conduct business or legal transactions through another person. Because of this, the law treats the act of the agent as the acts of the principal, as long as the agent acts within his authority. An example of agency is a property broker who sells property on behalf of the owner. Another example is a lawyer who represents a client in the court. In both cases, the acts of the agent legally bind the principal. Now let us understand how an agency relationship is created. An agency can be created in different ways. The most common way is when the principal expressly appoint an agent, either orally or in writing. This means there is a clear agreement where one person authorizes another to act on his behalf. Agency can also be created implied, that is, from the conduct of the parties or from the circumstances of the case. Even if there is no written or spoken agreement, the behavior of the parties may show that an agency relationship exists. Under the Indian Contract Act, the rules relating to creation of agency are mainly covered under section 186 to 118. Agency by necessity arises in emergency situations where action is required to protect the interest of another person. For example, a captain may take urgent decisions during an emergency to protect the ship and cargo. This creates agency by necessity. Another example is when a person accepts the benefit of an unauthorized act done on his behalf. By accepting those benefits, he said that to have ratified the act and agency is created. The next important concept is termination of agency. Termination of agency refers the end of authority of the agent. Once an agency is terminated, the agent can no longer act on behalf of the principal, and any act done after termination will not bind the principal. The termination of agency is mainly covered under section 201 to 210. An agency may be terminated either by the act of the parties by operation of law. For example, if a principal appoints as an agent to sell particular property and the property is sold, the agency ends automatically. The another example is where a principal revokes authority of the agent before the work is completed. From that moment onwards, the agent cannot legally bind the principal. Now let us understand the rights of an agent. An agent performs works on behalf of the principal. and the law ensures that agent is properly protected while doing so. Therefore, the Indian Contract Act provides certain rights to the agent so that the agent is not put to loss while acting honestly and within authority. One of the most important rights of an agent is the right to remuneration. This means that the once the agent has completed the work assigned to him, he is entitled to receive the agreed payment or the commission by the principal. The agent also has a right of indemnity, which means the principal must compensate the agent for any lawful acts done by the agent while carrying out the agency. The rights of an agent is covered under section 271 to 270 of Indian Contract Act. For example, if an agent sells goods on behalf of the principal and earns commission, the principal must pay that commission. Another example is where an agent incurs expenses while performing his duties. The principal is bound to reimburse those expenses. The next one is duties of an agent. An agent is expected to act honestly and responsibly while working on behalf of the principal. Therefore, the law imposes certain duties on the agent to ensure that the interests of the principal are properly protected. One of the primary duties of an agent is to follow the instructions of the principal. The agent must act accordingly to the directions given by the principal and within the scope of authority. The agent must also perform the work with reasonable skill and care and should not act negligently. Under the Indian Contract Act, the duties of an agent are mainly covered under section 211 to 216. For example, if an agent is appointed to sell goods at a particular price, he must follow the instructions strictly. Another example is where an agent handles money on behalf of the principal. He must maintain proper accounts and act in good faith. Now, let us understand the rights of a surety. Before going to surety rights, we need to see what is surety. A surety is a person who gives a guarantee for the performance of a contract or for the discharge of the liability of another person in case of default. The surety promises the creditor to take responsibility if the principal debtor fails to perform the obligations of. A surety gives a guarantee for the liability of another person, and because of this, the law provides certain rights to protect the surety from unfair loss. Once the surety has performed its obligation, means the if the surety guarantor has paid the debt to the bank that was taken by the principal, you should not be left without protection. Under this Indian Contract Act, the rights of a surety are mainly covered under section 140 to 145. One important right of the surety is that the right against the principal debtor. This means after paying the debt by the surety can record that amount from the principal debtor. Means the surety steps into the shoes of the creditor. The surety also has a right against the creditor. For example, the surety has the right to claim the benefit of any security that the creditor holds against the principal debtor. In addition to this, when there are two or more sureties, the surety has the right of contribution against co-sureties, meaning the burden is shared equally. For example, if a surety pays the bank on behalf of the borrower, he can legally recover that amount from the borrower. Similarly, if there are multiple guarantees and one guarantee pays the entire amount, he can demand proportionate contribution from the other guarantees. Now let us move to the next concept, that is discharge of duty. Discharge of surety means that the surety is released from his liability under the contract of guarantee. Once the surety is discharged, he is no longer responsible for the debt or obligation of the principal debtor. Under the Indian Contract Act, discharge of surety is mainly covered under Section 130 to 139. A surety may be discharged in several situations. One common situation is when there is a change or variation in terms of contract between the creditor and the principal debtor without the consent of the surety. In such cases, the surety is discharged. A surety is also discharged when the principal debtor is released by the creditor or when the creditor does act which is inconsistent with the rights of the surety. Further, if the creditor loses or parts with any security held against the principal debtor without the consent of the surety is discharged to that extent. For example, if a bank changes the terms of a loan agreement without informing or taking consent from the guarantor may be discharged from the liability. Another example is where the creditor releases the borrower from the debt. In such cases, the surety is automatically discharged. Now let us move to the next concept, that is gratuitous bailment. A gratuitous bailment is a bailment made without any reward or consideration. This means that goods are delivered by one person to another free of cost, either for use or for safe custody. Since no money or reward is involved, the relationship is based mainly on the trust. Under the Indian Contract Act, gratuitous bailment is dealt with under Section 159 to 162. Even though no consideration is involved under this gratuitous bailment, the law still places certain duties on both the bailer and the bailee. The bailee is expected to take reasonable care of the goods, and the bailer must disclose known facts in the goods. A gratuitous bailment can be terminated in certain situations. For example, it comes to an end on the death of either the bailee or the bailer. It can also terminate when the goods are used in a manner inconsistent with the purpose of bailment. A simple example of gratuitous bailment is when the person lends his book to a friend without charging anything. Another example is allowing someone to use bicycle free of cost. In both cases, the goods are given temporarily and must be returned after the use. Now let us move on the next important concept, that is lien. Lien means the right of a person to retain possession of the goods belonging to another person until certain lawful charges are paid. The important thing to understand here is that lien does not give ownership of the goods. It only gives the right to keep the goods until payment is made. Under the Indian Contract Act, lien is mainly covered under Section 170 and 171. A lien arises when a person has lawfully come into possession of goods and has incurred some charges or expenses related to those goods. Until those charges are cleared, the person is not bound to return the goods. There are generally two types of lien. One is particular lien, where the right is exercised only for charges related to those specific goods. The other is general lien, which allows retention of goods for a general balance of account, and this is available to certain professions like bankers. A common example of lien is a banker lien. If a customer has not cleared his dues, the bank may retain the customer goods or securities in its possession. Another example is when a mechanic repairs a vehicle and the owner fails to pay the repair charges. The mechanic can retain the vehicle until the payment is made. Now let us move to the last concept under special contracts, that is finder rights. When a person finds goods belonging to someone else and takes them into his custody, the law does not leave that person without protection. Even though the finder is not the absolute owner of the goods, the Indian Contract Act recognizes certain rights in favor of the finder, provided he acts honestly. Under the Act, the rights of a finder are goods finder of the goods are mainly covered under section 168 and 169. One important right of the finder is the right of lien. This means the finder can retain the goods until he receives any reward that was promised for finding the goods. However, the finder cannot sue for rewards unless it was specifically promised by the owner. The finder also has the right to take legal action to protect the goods from third persons. If someone tries to wrongfully take away the goods from the finder can approach the court to protect his possessions. This ensures that the honest finders are not harassed or exploited. For example, if the owner of a lost items announced a reward and a person finds that item, the finder has the right to retain the goods until the reward is paid. Another example is where a finder is in lawful possession of goods and someone else tries to take them away. The finder can legally protect his position. With this, we complete our discussion on special contracts under the Indian Contract Act. If you found this video helpful, please share, like, and subscribe. Thank you for watching.